What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And the final week of the Karen Reed trial is in the books. The jury has the case right now. Closing arguments finished today. My dad and I watched them while we played golf to start our Father's Day weekend early this morning. And we are going to break down this final week, get my dad's thoughts. What did he think of Wolf, La Posada, and Wrenchler? And then, of course, no rebuttal witnesses. We'll get his take on closing arguments, answer a bunch of the questions you guys have had throughout the week because I will pass them his way. Let's get to it. All right, Dad. Final week in the books. The jury has the case. They are currently deliberating. We're doing this at the end of the day on Friday. I would be shocked if they had a verdict before we were finished recording this podcast, but I guess it's possible if they go back there and decide very quickly. She is going to let them stay past 5 o'clock. But we listened to the final week. It was 3 defense experts, and we had no rebuttal case. So I want to start by talking about those 3 defense experts and then get your take on why you think Hank Brennan chose not to call any witnesses in rebuttal. Where do you want to start with Dr. Wolf?
Well, we can start just generally, Wolf. I know he started on Friday, but I think we should talk generally about him because
Sure.
he went on. He was ARCA. Everybody was anticipating ARCA testifying. The fact that they had to avoid saying the FBI and they had to say, I was hired by another agency. Actually, that happened. I mean, I can't believe nobody slipped, but it
So I had a
actually
question
came
about
true.
that because you said you wouldn't ask about that. You said you would just forego that and you would focus on the fact that you're a defense expert, you were hired. Now that you've seen how it's come out, and now that you've seen how it's juxtaposition between Aperture and ARCA, Aperture $300,000 or $400,000 they were paid, ARCA $50,000 plus $20,000 they were paid because this other employer hired them initially. Do you think that it ended up coming off better than you thought it would, that they were hired by some other agency, especially with the Jen McCabe conversations and Carrie Roberts and Dever, with this other law enforcement agency asking those people questions that was not Massachusetts State Police?
Well, I'm not a small mind, so yes, it has changed my mind. I have. It came across that they were almost neutral in their initial analysis, the first analysis.
Right.
That they came across as neutral, and I can't remember if it was Wolf or his partner that said we would have testified for either side. We were equally available to everybody, and that came across as great. And then later on, because we know from the jury in the first trial, apparently some jurors thought that the insurance company had hired them. Brennan opened the door for questions. You weren't hired by the insurance company, right? Yes, I was not hired by the insurance company.
Yeah, well,
So
Brennan said, you get hired by all these other people, including insurance companies, right? And then made it sound like that's what we got asked by. That's why Jackson had to come back on redirect and clarify. And then Jackson on direct for Wrenchler brought it out in the very beginning that he wasn't hired by the insurance company. You're right. I think that's really important based on what we know happened in the first trial.
So yes, after seeing how it came off and seeing that initially they made it look like the Commonwealth could have had them testify just as much as the defense. They looked a little more neutral, a little more detached for their initial report, and so I do think it came across better. And yeah, I think I was wrong. So
Yeah, and after listening to closing arguments, which we will get there, I think it's funny how this stuff happens, right? I can understand now why they called Dever. I still think they didn't love exactly how all that came out, but the way Alan Jackson was able to use her testimony to help paint the picture in a simple way of what this police misconduct can look like with the commissioner talking to her. So I do listen, there's a method to the madness, right? And
right.
I think there's multiple ways to skin the cat. So maybe it could have been good without Dever. Maybe it could have been good if they didn't talk about the third party agency that hired them. But the way it came out, they were able to use it in their story, in their presentation, in the evidence, in a way that was pretty effective. I do think it was pretty effective.
I do not think, I never thought it was a mistake to call Dever.
Right. I didn't say.
Yeah,
I
you
said
did.
that.
Yeah, I did not, because I thought she came across, number one, she gave them some facts that they could use, and they did use. Number
Mhm.
two, she also gave them the what a lousy police department and how corrupt they are. And so that was obvious from her testimony, all the way up to the commissioner's office. So, she came across as something they could use a lot in their closing, and they did
Yeah, the
use her in their
tidbits that
closing.
she gave Alan Jackson and what he was able to quote and how it was able to fit in, like her job depends on it. It depends
Right,
on what she says on that stand. I mean, it was chef's kiss, but I don't want to get us too off track. So back to
yeah,
Dr. Wolf. What did you
right.
find most compelling about his testimony? Because he was focused more on the damage to the car than he was on the damage to John O'Keefe's arm.
Most compelling was he actually did some testing, I mean, real testing that the jury could actually see on video, number one. Number two, and I think it was interesting that the National Hockey League,
Yeah.
how the forces used to break something, they had this little hammer contraption in order to prove how you can bang into something and how much force it takes to break. Just those kinds of experiments looked really good to the jury. And then the other thing that was really good were the side by side photographs. I thought those were very effective when he showed damage to the taillight versus the taillight on Karen Reed's Lexus, and
Mm.
how they just, no matter how many, and he did it at various speeds, it never looked like her taillight. So no matter what you did, you couldn't duplicate the damage on her taillight. And I thought that was really effective. The 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 thermal imaging was also effective because,
Yeah.
again, it shows science. Anything that you can show that's science to the jury that is not somebody's opinion. The fact that they froze the taillight, so they made it
Smart.
really, I mean, made it really look like they really did something that was accurate. They didn't just put on Mr. O'Keefe's clothes. They really did stuff. So I got to say, I thought that it came across real well, um, and that when they were done, again, done on direct, when they were done on direct, he really presented a scientific evidence of real doubt and the fact that there was no collision. I mean, and that was his bottom line, and he never wavered from it. That
What
was,
did you
again,
think?
talking about direct.
What did you think about the fact that, because some people were asking this question, now that I've seen the demonstrations done by Wolf, I can picture in my head now how John O'Keefe was clipped by that car, spun around, and fell back on his head. It gave them a visual of how you could clip and sideswipe a body and hit him just in the arm, and how that collision could work. Now, yes, of course, the tail light never broke that way. Yes, it never cut the fabric of the sweatshirt the way that it happened to John O'Keefe. And when we get to Wrenchler, obviously it creates more problems. But just visually for a juror that's trying to simplify it, and maybe they can't picture what it would look like for a car to clip somebody like that, and they gave them that picture with the defense's own expert. What did you think about that? Because Hank Brennan also used that in his closing argument.
I think that again, if the jurors were paying attention, and from all accounts they are paying attention, if the jurors are paying attention, they're seeing the physical damage that happened to the example that the state's Commonwealth's expert. Remember, they used an example, and this guy had injuries from his head to his toe, broken arms, all that stuff,
Not
and there
broken
was,
arms, but
well,
he had major lacerations and lower body
just,
injuries, internal injuries. Yeah, major injuries you'd expect to see in a car
yeah,
accident.
they had a whole list,
Mm-hmm.
and that list was not duplicated by the experiments that
Right.
were done by Wolf. So that's, to me, that's the contrast. Is if in fact this did happen, you would not only have the arm damaged or the light damage, but you would have at least some injuries similar to the injuries of the example of the Commonwealth's expert,
Yeah.
and they didn't. So I think that's the comparison that, again, if jurors paying attention, that's what they've got to look at.
Yeah, and like we say in our trials all the time, if a juror is going to think that, there's nothing we can do. Like if a
Right.
juror is just going to think everything points to guilt and there's nothing a criminal defense lawyer can say, then there's nothing you can do. And the same as vice versa. If they've already thrown out the Commonwealth's case and they think there's no way she did it, there's nothing Hank Brennan's going to say at this point to really change their mind. So you got to worry about what you can worry about, control what you can control, and present the evidence the best way you possibly can. You can't worry about every what if a juror might think about while you're in the moment trying the case. You think about that beforehand and you try to implement it the best way you can. But some jurors just end up on a side and will never leave no matter what evidence is presented to them. So, all right. So what about cross for Wolf?
Well, on cross, I mean, he took the qualification test twice, apparently. So
Only
that
part
was
of
a
it.
only part of it. So that was a big part of his cross. Um, and then we've got he deleted the texts. Then we've got the old Signal app that was also in it. So he went around. He spent so much time on things that didn't matter with regards to his expert testimony. Um, I think that he had a really good demeanor. Oh, another thing they did, his wife was on Facebook apparently supporting Karen Reed, which didn't matter. But what was really good about him is when Brennan would ask him questions that presumed a collision, worded in such a way that presumed that there was a collision, he never fell for it. He always said, "Well, I can't answer that because there was no collision." No, that didn't happen because there was no collision. So he was really good and really strong in making sure he stuck to his conclusion that there was not a collision, regardless of how Brennan asked the question. So I thought he did a real good job. His demeanor was very calm. He looked like an all-American boy. So I really think he did an excellent job. But I gotta say, and this is an overall comment, Brennan, to me, at least if I was going to score him or I was going to say, good lawyer, bad lawyer, Brennan lost a lot of points during the defense case. And this is an example of um, answer. He would respond like, "Oh, when you get uncomfortable with my question, is that the way you react?" I mean, statements like that from Brennan, totally uncalled for, totally obnoxious and rude. But Brennan is starting to make those statements. And he's starting to do things like this during the defense case. And he did it before last week. So I think Brennan is really deteriorating as time goes on in this trial.
Yeah, kind of
That's
like
just
when he
what I
said to Dr. Russell, well, since Mr. Alessi told you to ask for the transcript every time when I ask a question, and he would like start his question that way when he would be snarky with details matter, which I'm sure we'll talk about later. Yeah, I mean, I thought he did a pretty good job, a pretty decent to good job during the Commonwealth's case in chief. I even thought his opening was good, but it's just gone downhill. It really has
yeah.
gone downhill. I agree with you. Anything you want to mention on redirect? Well, you also
Um,
didn't mention on cross. Well, before we move on, I have to ask you about this. So he
okay.
asked about the holes in the back of the sweatshirt, and he's like, "Oh, what about this hole?" And he takes the plastic and he's like, "Here, here, 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 all these holes. What about all these holes?" And Wolf's like, "I mean, they don't look like road rash. They don't look like they came from a car accident. I don't know what they did come from, but they didn't look like any of that." And it turns out the criminalist, a Commonwealth witness, when testing the sweatshirt, cut those holes. And Hank Brennan knew or should have known that. What did you think about that exchange?
Well, again, that's another example of Brennan deteriorating during the case. Yeah, he should have known that. But my, I guess you and I talked about this. One of the greatest things I was surprised about. You got what, 7 lawyers working on this case over the defense side. Nobody knew that.
It's
Nobody
crazy.
knew when they showed the sweatshirt that that cut had been made by the criminalist. I mean, come on. Those guys should have known that. That objection should have happened right then, and they should have put a stop to it. Right, they could have made a big deal out of it in front of the jury if they'd have done it right then and really nailed it right then. But they didn't. They knew so much, but why didn't they know that detail? It just shocks me.
It's summertime, and everyone knows, especially in these hotter climates, that means it's time for sunscreen. But what if your sunscreen could do more than just block UV? That's what the scientists at OneSkin wondered. So they made a whole family of mineral sunscreens that target UV rays, free radicals, and cellular aging. The best part, unlike other mineral SPFs that feel heavy and chalky, these feel like skincare. Lightweight, breathable, and super hydrating. And now their award-winning OS 01 Face SPF comes in 2 deeper tints, formulated with non-nano zinc oxide, OneSkin's patent OS 01 peptide, and potent antioxidants that scavenge free radicals 4 times better than other so-called anti-aging SPFs. This sunscreen is one you'll be wearing all summer long. OneSkin is the world's first skin longevity company by focusing on the cellular aspects of aging. OneSkin keeps your skin looking and acting younger for longer. For a limited time, you can try OneSkin with 15% off using code LYK at oneskin.co. That's 15% off with code LYK. After your purchase, they'll ask how you heard about them. So please support our channel and tell them we sent you. Give your skin the scientifically proven gentle care it deserves with OneSkin. So their answer is it wasn't shown to us before it was shown to the witness. We didn't know what he was pointing to. First off, that's also an objection. Judge, objection. He's showing the witness an exhibit that he did not show to us first. They didn't make that objection. So it is interesting to kind of reflect back and think about. It is mind-boggling that in the moment they didn't do that. Now the X-rays could be different. We were all wondering about the X-rays. Why didn't they impeach Wrenchler with the X-rays? That could have been strategic because they were going to bring them in with their witnesses instead of letting Wrenchler look at the X-rays and say, "Oh, actually, this does look like a fracture," or "There's different ways you can look at this X-ray," or whatever. Forget about all that. You bring it in with your experts who say no fracture, no swelling, no evidence of an injury. That could have been strategic. I can buy that. This was not strategic. The way the Holes thing came out with Judge Cannoni's instruction, which was incredibly weak, in my opinion, they did not get to hammer it as hard. They absolutely hammered it in closing argument. He did a great job in closing argument. But in the moment, I agree with you. It is shocking that everybody working on the defense team, and even the 4 lawyers plus Karen Reed, who's very attentive and knows everything about this case, nobody jumped up when that happened. That is kind of shocking.
And you know what else? And again, I have been, in long, trials that have lasted 6 months, and I know you get tired. I know you get
a
fatigued,
lot of details.
But I would have not noticed if the state or the federal government had walked in with a plexiglass sweatshirt and
hold
put
on.
it behind.
They didn't. It was there before anybody showed up. It was up by the witness stand. So
Somebody had to put it there.
But it was when before the defense lawyers walked in is what they said. It was up there.
I would have still noticed it up there. I mean, it was not.
I'm not saying you wouldn't have. I'm just saying he didn't like walk it right by them to where they saw it. But they should have. I mean, if it was a document, we would all ask to be shown it before it's shown to a witness.
Right.
So that was. What did you think about her instruction?
Oh God, it started out pretty good. She actually had a longer instruction, and then she pared it down herself until it came down to a big, nothing. She should have, I think, in front of the jury, admonished the prosecutor, and she should have said something in her instruction that would negatively reflect on the prosecutor and the prosecutor's conduct. But she didn't. I think her instruction was really weak, and it was about as nice as she could possibly be to the Commonwealth, with considering that seems like a really wild mistake that, I find it hard to believe that was inadvertent, but maybe it was. I like to presume the best, but that's, again, another example of Brennan going downhill during the defense case.
Yeah, and there should have been something negative going the prosecutor's way in her comment. There wasn't. I actually don't know if she agreed with Alessi and gave an additional instruction. My guess is she didn't, but I didn't watch the entire charge conference today. All right. Anything else on what about Wolf's redirect or anything else on Wolf?
Well, the only other thing, and actually is the one thing that I thought in my mind actually mattered, was the weight of the arm.
Yes, I agree.
That's the one thing that may have mattered in this, is that the actual O'Keefe arm was 11.86 pounds. The arm tested was 9.38. So if you go by percentages, I think that's like a 25%, something like that, percentages. And then he's arguing about mass versus force and the formula. That to me said something. It made me think about maybe there was something that was different about that bigger arm. Now, they did not weigh O'Keefe's arm. That came from a statistical analysis of a person of that height and that weight. Statistically, that's what their arm would weigh, is 11.86. Because, of course, they didn't weigh the arm, because, of course, they didn't do anything in this case. So they didn't weigh the arm. But I think that's the one point that I think he did make a point of that would give me pause if I was a juror, that would make me think.
Yeah, I agree. And I thought, why didn't they just use the heavier arm? Like whatever the higher percentile was 12 pounds. So that would have made a lot more sense, but whatever.
Right.
I thought the defense did a good enough job explaining it to where it wasn't the biggest deal in the world, but that was a good point on cross. Anything else on Wolf?
No, I think that's I think that's pretty good. I think that using the dummy. I mean, We said before, why didn't they use dummies when they were doing these
We were
experiments?
begging for this from the Commonwealth's witnesses.
I know, and so I think that I think this witness was a good witness. I think was a good expert, and I think did a good job. So I would definitely give this one to the defense.
Yeah, yeah. Okay, next was La Posada. And before we get to her, there was a lot of arguments about what she would or would not be able to testify to. And Judge Canoni was not going to let her testify to dog bites at all, even though she had plenty of experience in it. And she used the defense's other expert, Dr. Russell, to say, oh, well, she had all of these things. And she mentioned like she had been published or something. And it's like, that's not, you don't have to be published in the area
No.
in order to be an expert, but that's kind of what she used as the bar. But after a lot of pushback and a lot of fighting and argument, especially from Jackson, she allowed her to say, consistent with an animal scratch or bite, which frankly was good enough for me. And La Posada was able to dig into that big time. So another defense expert in Emmy, she talked about hypothermia, the head injury, a ridge injury on the head, dog bite or animal bite, excuse me, and scratches with canine teeth. What did you think about her?
I thought she was wonderful. I gotta say that, and let me tell you a subtle thing that again, this just could just be me, but the fact that the defense had two female experts, I think that that's important because I think the female jurors identify more with those female experts rather than guys maybe telling them what to do, telling them what their opinion was. So I think that the having a sex balance in your expert
Yeah, they had
was
both.
very effective. I do. I think the I don't know what the final 12 makeup is going to be because I know we don't know that yet.
Well,
But if
actually,
that
we do. I just don't know what it is, but they called it
excuse
out
me,
already. They
oh,
called it
okay.
out already, so the people watching know what it was. I just don't. I didn't keep track of how many were male, how many were female. But we know there was some sort of a split, and you're right. And if anybody that thinks the Commonwealth had a female expert with Scorty Bello, she basically was not a Commonwealth witness.
No,
She was basically a witness for the defense. But yeah, that was a good mix. That's it is smart to do that.
yeah. So I think it is smart to have first of all the female experts. Secondly, she was terrific. I mean, I think she was unbending. She could not be intimidated. Uh, she talked. She was an Emmy. She's seen thousands of these things. Um,
She was
I tell
the
you what,
chief medical examiner of an entire state, even though it is the smallest state. That's a pretty big
right?
deal.
Oh yeah. And so, what did she say? She said a couple of really important things. And again, we all have to keep in mind reasonable doubt is the issue here. The defense doesn't have to prove anything, but the defense can create a reasonable doubt. The fact that she says that he died within 15 or 20 minutes of being hit, whatever he was hit from or however he was hit, that's how long he lasted after being unconscious. She was able to talk about the back of the head and a ridged surface as opposed to a smooth surface like grass. That's what caused indentions in the back of the head. Again, the word animal and dog, I mean, come on. That made no difference whatsoever to anybody that she said animal.
when you
Because
say when you say the injury to the back of the head, is that one of the times you're talking reasonable doubt versus proving something? Because I didn't find that overly convincing, but you're saying if a juror's thinking, oh yeah, that makes sense, you're just creating some reasonable doubt with a
I
testimony
am
like that.
because remember you had other experts that weren't saying that,
Right.
and she's saying that there are ridges, and again, if we assume the body was found somewhere within 50 feet of the flagpole, the odds are it's either in the snow or it's in the in the grass because at that time, remember the snow hadn't fallen that hard
Right.
yet; it was still very light. Um, she also really had a lot of common sense when she was explaining things. I thought that she did a real good job of understanding and explaining things to people. The X-rays,
Mhm.
she put those X-rays up there, and there is no doubt in my mind that the jurors remember the fact that the other Commonwealth expert said no X-rays. No
Mhm.
doubt, because I remembered it because I thought I cannot believe they did an autopsy and did not X-ray that arm. That was a shocker to me. And so I really noted that. Well, we have X-rays and we have no fractures. Very important. Next, we have
Not
the
just no fractures, no soft tissue injuries is what she says. Now, we all know MRIs are better for that, but still, no ligament injuries, no sign of swelling or trauma. I mean, she went as far as you can go with an x-ray to show no traumatic damage from being hit by a 6,000-pound SUV on that arm.
Oh yeah, oh yeah. And then no frostbite. You know,
That was
I
important.
think those are Boston jurors. I think they know. Snowstorm, you're out in the snowstorm, you're laying in the snow, and you don't have the proper clothing. That was important. He did not have the proper clothing when he's out there in the snow, and so he was going to get frostbite, but there was no frostbite. And then we have the Wisnowski stuff that they were talking
Spots,
about.
those Newski spots. Yep.
Yes, it's spots. Well, she says that those weren't Wisniewski spots, and they were not a sign of hyperthermia. He did not have hyperthermia. So she was just, again, to me, Russell and her were just dynamite. I mean, really, really dynamite. Um, and so, again, and of course, she said, there's no evidence. She does not believe he was hit by a car.
Oh, she
So,
said more than that, right? She's like, well, it
I
didn't
know.
happen. And
Yeah,
we'll get the cross. But
right.
did you think there were times where, because I felt like she and maybe Wrenchler felt the most like they were willing to go to bat for the defendant. Were they a hired gun? They were not going to give the Commonwealth an inch. They were going to push back. Russell really didn't feel like that. Wolf really didn't feel like that. A lot of the defense witnesses really, Barrows definitely didn't feel like that. But these last two really felt like we got to prove Karen Reed's innocent. It almost felt like they had a little bit more of that push. Did you get that vibe from these witnesses? And if you did it bother you?
I really didn't.
Okay.
And I tell you why. And again, just me. I felt, and this is not a negative comment, this is a positive comment. I felt she was very common. I felt she came across as not being slick,
Or
as not being,
condescending.
yes. I thought she gave nice, common answers. She's the kind of person that you probably would like as a doctor. And so I thought that she did a fabulous job of presenting herself and presenting herself to the jury. The fact, yeah, maybe she was pro defense, but that wouldn't, if I was a juror, that wouldn't surprise me.
Okay. Okay. So then on cross, Brennan wants to get into some credibility issues. There's more on cross, which you can talk about the whole thing. But when he was talking about those credibility issues, problems in her ME office, that she basically resigned in shame and that she screwed up some of those high profile cases, and other courts have found her to not be credible or to be a hired gun. When you hear all that, it sounds pretty good. Judge can only gave him certain things he could do and certain things he couldn't, but it looked like, oh, what I felt like was an amazing witness on direct as well. Maybe the credibility is going to get crushed on cross. What did you think of cross?
I guess, again, maybe it's because of so many trials I've seen. I did not think that the cross came across that damaging to her. I really think she still maintained her expertise and credibility after that cross. She explained the station nightclub fire, the complaints about that. She sent a staff person to the fire, and she stayed back. At the wherever the medical examiner's office was, and she was criticized for that, criticized for not going actually to the fire. So I think she had some good explanations. I think that, again, Brennan asked her questions that presumed there was an accident or presumed there was a hit, and she never wavered in saying, no, there was no accident, there was no collision. She backed everything up that she said during cross-examination repeatedly. So, again, she did not have maybe the opportunity that Russell did to give a couple of those two haymakers that we talked about earlier, where Russell really nailed Brennan. But she did not come across bad. I think she did a good job on cross. I also think Brennan may have learned some lessons from Russell and did not spend as much time trying to grill her as he did Russell.
Yeah, she was definitely pushing back on everything. Like when she said, "Well, it didn't hit him, so it doesn't matter." With some of the information, one of the best quote unquote points Brennan got on cross was, "You're not a neurologist, you're not a brain surgeon, right?" She's like, "No, I'm a pathologist," but that was the differentiation he could do. And I agree with you that what seemed like very strong credibility impeachment that he had came off so weak in the cross with this witness. He almost seemed too scared to cross this witness. And it turns out he has hired this witness a few times, which I found to be funny. Not overly unusual, right? That type of stuff can happen. But the way he was thinking about crushing her credibility makes it very interesting that he's used her in the past.
Yes. Okay,
Oh, I
that's
thought
all I
you were
have
going to
for
say
her.
something else. Oh, I thought you were going to say something else about that. Yeah, I mean,
No.
it's one thing to talk about how much money you make from the other side. It's another to say you're a hack, but a hack I've used. It's not really relevant. It shouldn't come in if the other lawyer hired the expert. It's not relevant to their credibility. It's not relevant to this case, but I do find it interesting when we find things like that out. Okay, next is Dr. Wrenchler from ARCA, the biomedical expert who's really going to talk about the arm injuries and how they coincide with the damage to the tail light.
Okay. He was, again, an excellent witness, a great way to end the defense case. And because they ended strong, he was strong. The He was able to say things like, "There's no evidence of that," over and over again to the cross-examination questions. There's no evidence of a collision. There's no evidence that the Lexus came in. There's just no evidence to back that up. Those were good phrases. One of the things I know that you've talked about is how who pushes the envelope as far as how you act in a courtroom, the defense lawyers versus the prosecutors, and the way you conduct yourself and the way you practice. And I think you said it, and I just repeat it, but defense lawyers, you're not going to get a reversal based on defense lawyer conduct, but you can get a reversal based on the prosecutor's conduct. And that's why a prosecutor really needs to be careful on how they conduct themselves. There's also a statement that some prosecutors' offices will say is there's no appeal unless you convict the guy. So, if you don't convict the guy, then there's not going to be an appeal anyway. So you might as well convict the guy and then worry about it in the appeals. Because I got to be honest with you, you and I both know there have been some cases that we thought were dead bang reversals. They go up for appeal, and the appellate courts here in Florida, we have a famous thing called PC affirm, per curiam affirm, where they don't even write an opinion. You send it to the appellate court, and they say, "No, we're not reversing it." They say, "Why?" We don't have to tell you. So they write these PC affirms. So appellate courts really, really don't like reversing, especially criminal cases. So prosecutors get away with quite a bit when they're doing things. And Brennan's, he's going to get away with a lot here. There are going to be a lot of presumptions. There's going to be some things that are going to be outrageous, but he's going to get a lot of presumptions of correctness as he goes through here. So I thought that was an interesting comment that you made a while back, comparing prosecutors and defense lawyers and how they should conduct themselves. Prosecutors should always, well, of course, defense lawyers should too, conduct themselves ethically within the bounds of the proper decorum in the courtroom.
It's not like one's allowed to be unethical and one is allowed or has to be ethical. That's not what we mean. It's just, and it's almost like one of those things that you know it when you see it kind of thing, because we've both prosecuted cases, we've both defended cases. The fire and passion and what you're willing to say and do and really pick at as a defense lawyer is just different than the prosecutor. Prosecutor's ultimate confidence, you should walk in, you should win every time. Like that's how it should be as a prosecutor. You shouldn't be like a duck where you're calm on top and your feet are which a lot of defense lawyers are, right? It's just everything's going a mile a minute. You're fighting a million battles, putting out a million fires while being cool, calm, collected. Prosecutors are the ones driving the boat. The defense lawyers and the defendant are in the back getting towed and pulled and trying to figure out how to come up for air, basically. And so it's a different job. It's a different vibe. And also what you said about appeals, I try to tell that to people all the time where it's like, that's great because now they have a great appellate argument. It's like, man, appeals are for losers. And don't forget that, because once you've lost, we talk about how hard it is for criminal defendants to win at trial. It is so much harder to win an appeal as a criminal defendant once you've been convicted than it is to win a trial. And I agree with you. It is very difficult to win a trial as a criminal defense attorney. So these appellate issues are not good things for Karen Reed. You'd rather have a fair trial the first go and give it your best shot.
Right. And on Welcher, he did all the things you'd expect him to do. abrasions are inconsistent with striking a car. That's inconsistent with this. There's incident with the X-ray. I think Brennan tried to hurt him with some things that again just aren't going to matter. Like um, he got real close, and it wouldn't have surprised me. And I don't know what the judge would have done if Welcher had mentioned the FBI, because in his
Brennan,
process,
it was crazy that Brennan was able to ask those questions about people feeding him information, violating a sequestration order, absolutely trying to hurt Karen Reed. Because, frankly, I don't think the judge should have found that to be relevant to hurt Karen Reed because Karen Reed had no control over it. That was crazy.
right, and the fact that the judge ruled that they couldn't mention the FBI, I think made these questions uh, irrelevant, or at least violated the court's order. Because how can you say, "Oh, you got to stay away from the FBI," yet you use it to impeach the witness? And that witness, if that witness had said it was the FBI that talked to me, it would have changed the whole tenor of that cross examination. The jury would have gone, "Whoa, the FBI, rather than some random agency." It
Well,
just shocks me that somebody didn't accidentally say, "Well, it was the FBI."
Well, because he's
That's
a
all.
pro and he was trying to play by the rules, number one. Number two, it definitely did not violate the court order because the court told him that he could ask those questions because he asked similar
Oh,
questions during the voir dire. No, she said, yeah, you're allowed to do that. I'm going to give you a robust cross to go as far into it as possible. You
no,
just can't
no,
say the
no,
word.
no. What I'm saying is the fact that you couldn't say FBI, that
I get
when
what
he
you're saying.
used that violated the court order, because she said they couldn't say FBI. Well, it would have changed the tenor of that cross examination, the beginning of that cross examination, if he could have explained that it was the FBI, and the FBI could have given her rats about her sequestration order. And the FBI was allowed to talk to him because they hired him. I
I get
think it
what
would
you're
have
saying.
changed it.
The only thing I'm taking issue with is you keep saying it's violating the court order. It is not. The court specifically allowed him to get into all of that information because she thinks it's this big nefarious collusion in the background between the defense and the FBI. I agree with you. It makes no sense how they could use it as a sword and a shield to make Karen Reed look bad, but she doesn't get the benefit of the fact that the FBI was working with ARCA is completely unfair. I
But
agree with
didn't
you also that it should have violated the court order, but it didn't.
but didn't she say? Doesn't she have another order that says they can't say FBI?
She
She
says
said that, right?
the defense cannot elicit that the FBI hired ARCA.
Okay, that's the order I'm talking about. Is
I
that
get it.
yeah?
I get
So
what you're
that
saying.
I
I mean,
thought I
it literally makes no sense because that door was blown wide open and they should have been able to get into it. But I don't know that the defense would have because everything they did in this trial tells me they were trying to keep it simple. They were not trying to make it so convoluted and make it a crazy web that's been woven, whatever, throughout all these years. That's so hard for the jury to follow and be so confused that I think they simplified it. And it was better for them this time that they didn't have to get into all of that even though Brennan was able to use it against them. Although, again, Wrenchler, like you said, such good answers to that. The organization that was giving me information, I was under the impression they were in communication with the court and they were allowed to give me that information. I mean, he handled that beautifully.
yeah. And he also said it did not affect his analysis or
Right.
his conclusion.
Mm-hmm.
That whatever they said didn't affect that. No. I think once he said that, my presumption was that they were in communication with the court on it. I think that just killed the Brennan's cross examination, and Brennan couldn't do anything about it.
Mm-hmm.
At that point he was stuck, and if he went any further, it was gonna come out. So
So there
he
are
was stuck with that.
a few other
Um,
questions I know everybody has for you. Number one is what did you think about the ham sandwich? And
I, he remembered the ham sandwich, but he didn't remember any of the conversation. Uh, I thought that was meaningless. Um,
what do you
then
think
he
about
had a
generally driving back and forth with witnesses and having lunch with an expert witness or getting them an Uber to the airport or having them come to the hotel to prep with you? Like, what do you think about that generally?
Well, I don't really know how the jurors were affected by it. I can tell you as a practical matter what life is really like. And life is really like I've had high profile cases that had changes of venue where you had to go to another county and try a case in another courthouse. And that courthouse had one hotel within walking distance of the courthouse. In that hotel, we all stayed, the defense lawyers, the prosecutors, the judges, the agents, the witnesses. They all stayed in one hotel. And at night, if we wanted to have a drink, we went down to the bar and had a drink, and everybody was there. And in fact, this case was an interesting case because F. Lee Bailey was one of the defense lawyers on the case. And another one was Henry Gonzalez. And Henry was this jovial guy. And whenever Henry was in a bar, he picked up the tab for everybody in the bar. Now, as prosecutor, I was a prosecutor then. We did not allow him to buy our drinks. We didn't do that. But everybody else, including the witnesses and everybody else down there, Henry picked up all the tabs for everybody. It's just not unusual. It just for you to have to and if you're an out of town witness and you're an out of town lawyer and you're staying at a hotel, why wouldn't you put your witness in the same hotel you're staying at? Why wouldn't you have to pay for a cab? You have to charge your client a cab fare. Why wouldn't you drive there? So again, I don't know how that affects a juror. I don't know if a juror thinks it's odd, but it's not. It's every day, and Brennan knows it, and that's kind of another kind of sleazy thing he did, is because I guarantee you he's done it 1,000 times.
Yeah, and he even asked for the instruction, like, just because a lawyer talked to a witness or prepped a witness, that's their job. That's what they're supposed to do. We all know that. It's in the jury instruction. The jurors' eyes were probably glazed over by the time the judge was reading those instructions, but we all already know that. The second question I know everybody's going to have for you, you may have more on Wrenchler, but I want to make sure we get these are kind of two of the main questions. What did you think about his description and smashing Welcher, the Commonwealth's experts, test or experiment or whatever he did, and the fact that Brennan was like, we never said that he was hit with his arm bent. We never said he was with this. We never said this detail. We don't know. We don't know. What did you think of that kind of form of cross-examination?
Okay, and I wrote that down where he asked a bunch of questions in order to get these answers. I mean, these are the answers he was looking for. We don't know how far the debris field has spread. We don't know how far the body moved. We don't know the body's position. We don't know how far it was thrown. Um, they didn't know any of that stuff. And every time he asked a question like that, all I could think about was his expert. And I could think about, his expert basically said the same thing. There are too many variables.
Mm-hmm.
And it was reinforced by Welcher. There are too many variables. We don't have the evidence. There's too many variables to test how exactly this happened. Over and over again, he asked questions that I thought were exactly those kind of questions that also hurt his own expert, because his own expert talked about variables as well. So I think that's the area you're talking about, right? When he went
Yeah.
through all the variables, yeah. So
Well,
I
the variables, but then also, what did you think about what he said about Welcher's test? Which basically, if he wasn't showing us that the tail light could hit the arm there, his test was completely worthless. What was the point of the test?
I think maybe I missed the particular answer you're talking about. That Welcher. What did Welcher say?
I'm talking about Wrenchler. So
Oh, Wrenchler.
Brennan is crossing Wrenchler, the defense
Right.
expert, about Welcher, the blue paint test, and he
Oh,
says, like, I thought the point of that was to show the tail light could hit him in the arm, and Brennan's like, oh, that's not the point of that test. And Wrenchler's like, well, then seems like the test was pretty worthless.
you're right. And the arm, the level of the arm, where the arm
Right.
was. I think they Wrestler talked about that. Talked about we don't know if it was up or down or here or how it was. Another thing, if you remember back, that the car can go up or down 5 inches, and so we don't really know exactly where it hit. Yeah, he basically again was hurting his own expert's credibility,
Mm-hmm.
and I think that came out, and the jury's going to remember that because this is the last witness.
Right. So anything else on Wrenchler that you had?
Let me see. Well, of course, he said you can't prove that the collision even occurred. He said that a bunch of times. There was no evidence of that. He talked about the pieces of the tail light, and I thought he did a good job of handling the fact that the taillight pieces really couldn't have cut him or done the damage that they're talking about. Um, and there was no rebuttal on him. They didn't ask anything. So I think he did a good job, and it was a good way for the defense to end the case or end their
Yeah.
defense case.
No, I agree. I agree. I think he was a great witness there at the end. And then we expected witnesses to come and talk about no dog DNA, that this was not a dog bite. We expected a dog DNA person, a dog bite expert, and Welcher to come and take the stand again for the Commonwealth to have the last word, which is their absolute right. They have the burden to prove the case. They have they have the ability to go last in a rebuttal and respond. And the judge gave them a gift and was going to let Welcher testify to even more than he would otherwise be able to testify to on rebuttal. And Hank Brennan gets up and says, after the defense rests, we will not be calling any witnesses in rebuttal. What did you think
Well,
about that?
well, I can tell you, I can understand why they didn't put Welcher on. I think that there was too much they could ask him now after the experts, after ARCA testified, after the X-rays. He just was too vulnerable. Uh, and you look at the questions that the cross-examination that Brennan did about, well, you didn't know how far the body was thrown. You didn't know, those same questions would just his client, his expert's going to have to answer them the same way that the defense expert did. So I think he was too big a risk. However, if I was Brennan, I would have thought of somebody to put on.
I
I
agree.
would not have done this. The last thing the jury is going to remember is the defense expert saying that there was no collision. So I really think they made a mistake. I would have put the dog bite, somebody up there, so that they would have had the Commonwealth's theory of something that they went away with at the end. Commonwealth really gave up a lot by not putting on some kind of a rebuttal case. So I think it was a
Yeah,
big mistake.
and you can understand why he didn't call the dog DNA person, because he was able to put it in himself with the questions with Dr. Russell and tell it the way he wanted to without the defense picking apart the problems with exactly how that dog DNA was gathered, where it was gathered, what was swabbed, what wasn't, why is there pig DNA? Like, they didn't get to get into any of that. So I understand why he didn't call that witness, but it's like, this is the other way. This is the other way around. This isn't how it should be. You're the Commonwealth. You should have all the evidence in the world to be able to bring something back up on rebuttal. And they were just too scared that the defense was going to nuke it. That's really what it felt like.
Yeah, I think so. I, I think that they are, like I said, Brennan's demeanor, attitude, all that stuff got a lot worse during the defense case. I think he psychologically is beaten up by the defense. I mean, no one's going to admit this, but I think he was psychologically beaten up by the defense case. Nothing he did during the defense case really worked for him. He asked questions and he got slammed in the face by the answers. That's Russell's a prime example of that. So I think he just was scared and said, "Boy, I better leave well enough alone because I'm just going to dig myself into a bigger hole if I put on a rebuttal."
And it's almost like at the beginning, he was trying to be a defense lawyer. He was trying to poke holes in some of their theories. That's not good enough. You have to eliminate those theories. You can't just poke holes in reasonable doubt. You have to eliminate reasonable doubt as a prosecutor. And maybe he realized it wasn't working, part of the way through. But then we got the jury instructions, and there were three instructions that were abandoned or withdrawn. One was the third party culprit instruction. One was the missing witness instruction. Those were the two defense ones. Then there was one on the Commonwealth side. But what did you think about withdrawing those instructions? We've heard the closing. They did not abandon those arguments at all, but they didn't end up asking for the instruction. Any significance to you?
Yes, I've done that before too, because I'd rather let the jury make up their own mind about what is the instruction rather than the judge tell them. Because I believe it was I can't remember which one, but
The
one of
missing
those
witness
two
had like a
instructions.
bunch of boxes you had to check
Right.
before you can have a
Maybe that's
negative
it.
inference.
I
Yeah, it's
remember
just
reading
simpler
one of
for.
them. Yeah, and it had requirements.
Mhm.
You have to do this, has to happen, this has to happen, this has to happen for you to do. All right, I don't want no stinking requirements. Let the jury decide whether or not it's worth or not. Yeah,
Mhm.
I've done the same thing. I think it was the right thing to do because I'd rather the jury make their own decision about how they're going to treat missing witnesses or third party or whatever they want
Well,
to call
he
that.
did the hybrid. They ended up doing the hybrid Bowden and third party.
Right.
But
So
sometimes it's really great when the Bowden instruction is really great when the judge tells you if this investigation is this bad, hold it against the Commonwealth. Sometimes it can be really great. Sometimes they can be too complicated and convoluted because lawyers are writing these instructions and they can be so confusing. So that's why there's strategy in everything, including jury instructions. And the Commonwealth ended up abandoning the consciousness of guilt instruction. They still made that argument, but they abandoned that instruction. Same kind of thought.
yes, and the bound instruction, I read that too. That's a really pretty good instruction.
I agree.
Uh, yeah, I thought that one is really well worded. It's short enough and it's easy to understand. So I agree with the abandoning of the instructions. It also makes life simpler for the jurors because you know instructions are complex enough. If your listeners are going to listen to the jury instructions, they might listen to them, but they're
Some
pretty
did.
complex. And understanding every instruction. I don't know if Massachusetts sends the instructions back with the jurors. I know Florida does,
Mhm.
but I really think it was the right decision by the defense. Prosecutors, that's up to them. I'm not so sure either way. But the
That's a
defense,
good point.
there's no doubt in my mind for the prosecutors, for the defense lawyers, it was the right decision.
And I agree with you. I don't know about the instructions either. I said yes, just like I said the prosecutors are going to go first and last, which is wrong in Massachusetts. Just the defense goes first in closing, and then the prosecutor goes last. So everywhere does it a little bit differently. I think that's kind of crazy. If I was a prosecutor, I would much prefer to go first and last because you can split that time up. That's not how they do it there. So we get to closings when you have a long trial. This is 6 or 7 weeks, something like that. You've had trials. We've had trials together that have lasted that long. You've had trials that have lasted much longer, like you said, 6 months. How do you prepare for a closing argument? What details do you choose and not choose? And did you think an hour and 15 minutes was enough time?
Hour and 50 minutes was definitely not enough time. It was just way too much to cover. I am, like you've said many times, I know before, jury selection is all important here. I just hope they picked a good jury because honestly, I'm going to make my prediction now. You want me to make a prediction?
Sure, let's hear it.
All right. If the jury is listening and they're paying attention and they're doing the right thing, it's a not guilty. I absolutely
On
believe
all
that
counts.
on all counts.
It's
What I'm
just if this was a
concerned about
normal
is
case,
the
before we get to your concerns, if this
yeah,
was a normal case and this criminal defendant's name was John Smith and you just got done trying this case, you'd be supremely confident in a not guilty verdict,
right.
right? I
Oh,
mean,
absolutely.
that's what people don't understand. Like this is a because it's so high profile, because it's so intense, the resources spent in a normal case, we could have probably got this case thrown out. They probably would have no infoed this case after they were presented with the evidence. Normal prosecutors. I truly, this is not like I'm trying to side with one side or the other. It's like looking at this case, it's shocking to me that we are here. There is so much reasonable doubt across the board. So much. Is it possible she hit him? Sure, maybe. Okay. But the science certainly doesn't seem to make it possible. The testimony is certainly suspect. The things going on in the background is certainly a problem. But I mean, it's crazy to me how we look at this case. Okay, what are your concerns then? You think it should be reasonable doubt, but what are your concerns?
Well, let me jump to what
Sorry,
you
I
just
said,
said
hold
about.
on, I
Let
said
me
reasonable doubt. Let me correct that. You said you think it's going to be not guilty, but what are your concerns?
let me go to you. You raised an issue about this would have never been filed in a normal case, and you're absolutely right. This would have never been filed because remember, when this case came into the office, they did not have Karen Reed's interview.
Yeah.
You know, which I think is one of the most damaging things in the case. They didn't have her interview, so when it came into the office, they just had these cold facts, and it would have never gotten filed. At least I don't think in Florida any prosecutor's office would have filed this case.
I agree.
Now going back to my concerns from reading some of the comments of your fans, there are some fans that are absolutely convinced of her guilt, and they unequivocally they say it. Now I'd be happy to argue with them why I think they're wrong, but they're saying she's guilty. There could be jurors on there like that were. If you remember the beginning of the case, I said that Brennan front loaded the case because he put those things on that he thought were the best things for him to show her guilt in the beginning of the case. So that there are some jurors that their minds will shut down after hearing that, and they heard nothing else after that. So I am concerned that there may be a juror or two like that. They'll never get a guilty on anything, even a lesser included. They're not going to get a guilty. They may get a hung jury because we have a rogue juror on there that is just absolutely believes she's guilty no matter what the evidence says. But it should definitely be a not guilty.
Yeah, I if I was gonna, like I said, bet not guilty would be the best odds, hung jury would be the second best odds, and guilty would be the least odds. And then if we go to where the guilty odds land, a lesser included of count two, like an involuntary manslaughter, I think has the best odds. I'd be shocked if count one or count three, because of the intent and knowledge and wrongdoing that has to be involved there, I'd be really shocked if one or three was guilty. But man, I'm not positive that there's going to be a not guilty verdict across the board. We know jurors like to compromise. We know, if jurors really can't agree and they get in there and battle, maybe it's a hung jury. There's just it's not the easiest thing in the world when you have a multi-count complaint like this and they have multiple charges to get a not guilty verdict. But that's a good transition into closing arguments. Is there something else you want to say before we get to closings?
I was just going to say that when we're talking about the jurors, I guess there's a juror there that's like about a 25-year-old male.
Okay.
And this is something I've read, so obviously I haven't seen this.
Mm-hmm.
But apparently, that juror, every time Brennan yells, jumps. Yeah,
Interesting.
I mean, literally goes like this when Brennan yells at a witness or something. And I just want to bring that up because that's an important aspect of this jury is their age, their sex, and again, their personal experience. So selection was really important.
Oh yeah, absolutely the most important. And those same fans, everybody sees everything a little bit differently, right? Same people that are watching us every time that, love everything you have to say, hate everything I have to say, vice versa. Say I interrupt you too much. I don't let you talk. I wish you would talk more, frankly, in these podcasts as well, so I could rest my voice in them a little bit more. But everybody just sees things a little bit differently. And when you get back into the room, all 12 voices matter. They've got to come to a consensus and a unanimous decision. We had closing arguments today. Jackson went first. What did you think of his closing argument? We don't have a ton of time, maybe like 10 minutes. So,
Okay.
what did you think of his closing argument overall?
I thought Jackson did a very good job. He did it with he backed up what he was saying with evidence, testimony, and citations to time, place, what he was talking about. He did not deal much with the hypothetical theories. He was much more, and I like this phrase he used, that science was a silent witness. I
Mm-hmm.
thought that was an excellent phrase because he is depending on the science to find his client not guilty because obviously if you depend on her statements, I hit him, he's guilty. So you can't depend on your client's statements. You've got to depend on the science. And I think he did a good job of doing that. And he backed up everything he said with testimony and citations. Did a good job.
He completely ignored the clips, basically. Completely
Yeah.
ignored the clips of her from the interviews, which I thought was interesting. He didn't even say they were snipped out of context. He didn't even make that argument.
See, I would
So
have
yeah,
I
overall,
would have played more clips probably if I was him to take as much of the um, uh, shock value out of the prosecution's closing argument. But again, he decided not to do that.
he played a few clips. He played a few clips, especially of the waterfall, and kind of told
And
the
then the
story.
kiss, he played the kiss.
Yeah, yeah, yeah. Um, and then what did you think of Brennan's closing?
I thought, I mean, I hate to say this, I did not like Brennan's closing. I thought Brennan, well, he had two parts to his closing, basically.
Mhm.
He had the part where he told stories without backing the stories up with evidence. This is what happened. But they did this at this time. But he had no citations, no evidence. He just was making it up, basically saying, look, your common sense will tell you this and that and that. So that was one part of his closing, and I didn't like that part. The other part of his closing is he asked some questions like, why would she do this? Why would she call so and so at 5 in the morning? Why would she worry about this? Why would she say he was
Well,
hit by a snowplow?
why would she call her sister and or why would she call Jen McCabe and ask where John was and not ask her what time did he leave the house? Why would she say she left him at the waterfall? Why would she say he was possibly hit by a snowplow? Those are some of the specifics that he brought up that I agree. I said the same thing in my video breaking it down. That's those are good questions. Why did Karen Reed act like that in the morning after? Now, Dr. Russell may have a good example, but or reason for it, but
There's a problem though with that,
mhm.
and it's a problem with the way they do closing arguments. Those are not the right questions. Yes, we can sit and wonder about those, but
Mhm.
the Commonwealth has the burden of proof.
Correct.
I don't have to answer why my client didn't do something. You, however, have to prove why they didn't do something.
What she did.
You know, so I'm saying is that Brennan is saying find her guilty because she didn't. Basically, they had an argument early on in this. I think it was this week actually. They argued about burden of proof and how Brennan
Burden.
was shifting the burden of proof right
Yeah.
to the defense by the way he was asking questions, inferring that the defense had something to prove. This closing argument definitely inferred that the defense has something to prove and they didn't prove it. Therefore, you should find her guilty. And although I thought that was the best part of his closing argument, I found it to be an improper closing argument because I do think he was trying to shift the burden of proof.
He was basically saying Karen Reed was acting sus, therefore she's guilty, and that's just
Right.
not good enough. I thought the best part of his closing was potentially the timeline, where the phone was, where the Lexus was, when the Lexus, he says, backed up, when the phone stopped moving, the temperature of the phone, when the phone started moving again is when Kerry Roberts grabbed it. The phone data picked all that up. I thought that was probably the best part of his closing because at least he had some data there to back up the story he's telling. He completely ignored all of the problems with the tail light, the arm, the dog bite. He basically completely ignored it, barely touched on it. It was, 1% of his closing. But if I was going to pick he basically tried to make an Occam's razor type of this is the simplest example. This is probably what happened. Therefore, we need to convict her. I mean, if I'm trying to, it was a struggle. It was a
Let me
struggle.
tell you just one other quick thing that I may or may not be important to the jurors when they get back in the jury room. If they were keeping really good notes of the opening statements, both of the defense and the prosecutors, this case ended up being totally different than those opening statements for both sides. If they were keeping track of what Brennan said, this happened at this time, this happened at this time, this happened at this time. Well, when it got down to closing arguments, those things didn't happen at that time.
Mhm.
So there was a lot of discrepancies in the events as Brennan laid them out. And the other thing is Proctor. How about the way Proctor was presented in those opening statements, yet nobody called Proctor? Who are they going to blame for
Mention
not calling
Proctor.
Proctor?
Brennan
What?
didn't even mention Proctor in opening at all. Brennan never
I know,
mentioned it. Yeah.
I know it. So who are they going to blame for not calling Proctor? Are they going to think maybe the defense should have called Proctor uh, instead of the prosecutor? And I know that uh, Jackson dealt a lot with
Yeah.
the responsibility of the prosecutor to call Proctor, and he dealt a lot with Proctor. He had what he needed for Proctor for sure. But if they remember, the defense mentioned Proctor a ton in that opening statement, and yet we never heard from Proctor. So I'm wondering whether or not they're going to think about that.
I mean, I think he did a pretty good job explaining how
Oh,
that
I think
should have worked and how it wasn't and how good that was for them personally. And then the way Hank Brennan explained it, like we didn't need Proctor. Okay. But yeah, I agree with you that Jackson's opening did make it seem like they were going to hit that 227 House Long to Die in the Cold search a little bit more. There were definitely some things that he said in his opening that they adapted throughout the trial, which is no surprise. It happens to every lawyer. But the Commonwealth's timeline changing is potentially a much bigger deal to some jurors. I mean, I guess we'll see. Do you have any prediction on how long the jury will deliberate?
I'll give it. I will. I'll predict this. They've started already, right?
Yep.
Okay, so they did a
They're going to get
half
a
day
couple
today.
hours in on Friday.
Okay, they'll put a full day in on Monday. I'll give it Tuesday.
Yeah, I said Monday night, Tuesday. I think it's either late Monday or early Tuesday. That's my guess. It's not going to be, I really don't think it's going to be tonight. They'll just start and then they'll come and rehash it. And sometimes jurors want to go home and sleep on it after they've made their decision Monday. It was a hung jury. So it was days and days. It was multiple days last time. I want to say 3 days. I can't remember. I can't remember.
Well,
That's easy. The
if,
people in the
well,
chat will
let me
know.
tell you, if it goes past Tuesday, then your odds on a hung jury really went up.
Oh, yeah. Big time. Big time. All right. that is the last week. We are going to do another podcast next week, post-verdict, discussing the verdict, what we think about the verdict, why we think it happened, whatever that verdict is. By the way, anybody listening, whatever the verdict is, don't do anything wild. Don't do anything rash. There's going to be appeals if it's a guilty verdict. There's going to be, regardless of what happens, okay, there are going to be people saying it was rigged. There's going to be people saying this was unfair. It was either outside pressure or corruption or whatever it is. Just realize that we should not do anything illegal, immoral, or horrible to anybody after this verdict. That is not the way to handle it. And I should start saying that now because I know people's imagination can run wild, and I think it's important to push back on that. It's kind of like when we tell our family and friends of our clients, like, don't show an eruption of emotion when the verdict is read in court, because nothing good usually comes from that. They don't always listen, but we try. Okay. Anything else you got?
Nope, that's it. And
all right.
I thought, by the way, Karen Reed still is interesting. After every day, she's still coming out and giving little interviews on the steps of the courthouse. She's still doing that.
Yeah. Yeah, it's interesting because there's a gag order on the lawyers. But all right, that's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.